You got to be quick around here. Hey, good evening.
Hi, Stacy Armato, 208 28th Street. Lately, I've been fielding a lot of the oil questions, and one question that I just can't answer are related to the mock jury trials. So I asked our city attorney if we could go ahead and release those, and apparently they're still under an attorney-client privilege that can only be lifted by the 5 of you. So I'm asking if you would mind, in 2 weeks at the next meeting, if you could agendize discussing lifting the attorney-client privilege on those mock jury trials so we can have better information on that. Thank you.
Anyone else?
I have a question here for the city attorney regarding that. I don't really understand this because the mayor has already partially released some of that information. So how can one individual have the authority to release documents that are protected, and then when others ask to see all the documents, we're told that, no, you can't do that? I'm just trying to figure out why, if it's been made public, we wouldn't just make them public.
The attorney-client privilege is held by the city as an entity. You are the client. And the 5 of you acting as a body, as a city council, your actions reflect and represent the actions of the client. You are the embodiment, in other words, of the municipal corporation that is this city. Official actions can only be taken by the city council acting as a body, not by any one individual. No individual on this council is empowered or authorized to waive the attorney-client privilege. Only the council can, as a body, waive the privilege. It may be that from time to time an utterance is made, something is revealed that's not authorized by the body. That does not represent a waiver of the privilege. Only the council can waive the privilege. You've been asked to waive the privilege. You can certainly do that. And if you do that, we can make some information available. And that would be entirely up to you and your discretion. I know that there was some partial information that was publicized. It was not by any stretch the entirety of the report. The case law says that a disclosure of a portion of an attorney-client privilege document does not represent a waiver. And in this instance, it couldn't have represented a waiver because the city council didn't authorize it. So as it stands now, from a legal point of view, it has not been waived.
Disclosed. I'm confused by this because you're saying only this body can approve the release of that information. This body did not approve the release of that information. An individual released the information that was. So I'm a little confused. So tell me why. And tell me, once we open that door, how we can then pull it back and say, I'm sorry, that was my little, my little nugget, and we're not going to release any more information. Yet in that presentation, which was under the guise of State of the City, it was a key component of that in terms of where we were and why decisions were made. And I'm just trying to understand how an individual could do that without consulting with this body as to the appropriateness or inappropriateness of it, and why that wouldn't consider some sort of breach.
Okay, that's a different question. And perhaps that question is best directed at your colleagues. I don't really have an answer to it. I will tell you that as a legal matter, that the disclosure did not, in my judgment, waive the attorney-client privilege. That rests with the City Council. You are the client. If you wish to waive the privilege, if you believe there is no reason to not disclose the information, if you think that fairness and community debate and dialogue dictates doing so, then you should agendize it for your next meeting, and you should do so. But I answer your first question.
Well, then I would certainly make that motion that we do agendize it, and hopefully in that meeting that you would return, and staff if need be, and give us some cogent arguments why or why not. I mean, I think that it's merited. I just think you can't release a part of a document and then characterize the whole totality of it that no one has seen. And I've not seen any of this because these mock jury sessions were superseded many of us who are seated up here on this council, and I have never seen that document until those slides were put up on that screen during that presentation. And so I think it certainly warrants a full discussion, and let us decide whether or not we want to or don't want to, but I think the argument needs to be made why or why not.
Okay, anybody else?
I'll second the motion.
I don't believe it. Can we get through announcements first?
Here's the motion.
What is the motion?
The motion is that we agendize this be brought back at the next meeting.
Gentlemen,
I'd like to speak to it for a second.
go ahead.
I think it's fair to say, Mr. Duclos, I don't think any of us have seen it. I know I haven't as well, so it wasn't just something that superseded your time. Do we, either of the five of us, have the ability to read that document today, tomorrow, if I came to your office? Do I presently have the authority to read that?
Any one of you could read it if we had it. I don't have it.
You know, just so
I've never had it.
So nobody gets squirrely about it. Who has it? And just explain that a little bit.
The law offices of Bird Morella,
Who was our
litigation counsel in the Macpherson litigation, commissioned the mock jury exercise for purposes of trial preparation. And the product of that exercise is considered to be what's known as attorney work product. Basically, it is a classic exercise of what attorneys need to do in order to prepare a case for trial. It is confidential and it is privileged. The actual report that was prepared, I don't believe has ever been in possession of the city. There was a report made to the city council in closed session regarding that exercise by the attorneys at the time that the exercise was done, but I don't believe a report resides here in City Hall, and one does not exist in my files either. So, as a practical matter, we would have to obtain it from our attorneys, and it's our right to do so and make it available. The slides that were presented in the State of the City address were just a small portion of the full report.
But clearly they were in the
Can I,
possession
hang
of...
on.
I am sort of constitutionally interested in doing this, but I am incredibly alarmed at having a public discussion about a private document that I've never read, and I have no idea how to process the other implications that document or other documents that are owned by our that reside or work product of our attorney have on our long-term issues. This is a quandary. I'd like to maybe propose a friendly adjustment to the friendly amendment that we agree to put an item on other matters at the next meeting that calls for the item to be agendized at the following meeting, and between now and then document and we individually read it so that we can understand what's in it. I mean, look, I think what we were presented was that the data is revealing, but what about the next work product? And at what point do we stop work product releases to protect the community from long-term things, mindful that we haven't completed our portion of the settlement? And that worries me. It really worries me. I hear where you're coming from. As I said, I'm constitutionally set to share everything. But what else is in the work product that we're going to then talk about in November and then something in December? And I don't want to blow that up because I don't know what those are, but I don't know what those are. And I think there is a point where in service of releasing data, we're going to damage, I have no idea what we would. We could theoretically damage future legal issues that we have related to this whole thing from either side.
I clearly I sense why you're troubled by this, and I think that it's a tough balance here that you're all struggling with, because I think that you genuinely would like to, if at all possible, err on the side of disclosure and allow for dialogue. I think that the part of the problem on the other side of that is that the mock jury exercise is an extremely nuanced sort of thing, and so it's not all that easy to understand out of context. And what we are talking about here is about as classic a case of Monday morning quarterbacking as you will ever experience, because you have to have been a litigant in litigation, and you have to be in that situation where you are faced with a trial and where you are consulting with your attorneys and you are being provided with a lot of information. It's extremely complicated, and you are being advised of the strengths of your case, the weaknesses of your case, the risks associated with the case. The mock jury exercise was just one small piece of information. It was not by any stretch the driving consideration. It itself, is an imperfect tool. You hired expert lawyers who were there to advise you and to assist you in the litigation, and you're at a point where you have to make a decision as to what's in the best interests of this community in the long term. And it's very difficult if you weren't in that room, and you were, hearing all of the advice, having all of the information, and faced with the imminent trial, to truly understand being in that situation. There are many people in this community who have been in that situation, who have been litigants, or who are attorneys and who advise clients in litigation, who understand this process. And so I'm not saying anything that's mysterious or secret or anything all that novel. But what I am suggesting is that it's a very difficult decision to second guess. It's no different than, it is no different than Monday morning quarterbacking. You can second guess that coach all day long on Monday morning, but when that coach is there making that decision of which quarterback to use or which play to run, that's the moment, and that's a difficult moment to second guess a day or two later. It's easy to second guess it in some respects, but it's also very difficult because you don't have all the information. So, I leave you with that. You can certainly put it on the agenda. You can certainly consider the pros and cons and do what you think is best. I don't think that a tragedy will befall the community if information is released. But I also think that the information is subject to being abused in certain ways.
Understood.
Peter, did you have anything?
No, sometimes I think maybe should go to a closed session first and have you report on, we're just asking for the mock jury transcripts, I'm assuming, not the whole boxes and boxes. So, and we did this twice. I don't know if they want both mock juries or the last
We only did it,
one.
I don't think we didn't do it a second time.
Yeah, so.
We were going to, but we didn't.
Yeah, we never did. But we did prepare for that. So sometimes I feel that I hear what Michael's saying is damage to the city. There was a lot of preparation to get to that mock jury. That information isn't what they're seeking. It's just what happened at the mock jury, I'm assuming.
I want to
So
speak to...
I'm just not quite sure. I don't think it's a problem, again, what happened at the mock jury. They're not going to get, the other information is reams and reams. And I don't disagree with the city attorney that you can armchair quarterback this thing from now and forever. But if it's, I don't have a problem revealing it. I just don't know if our city attorney we should look at this at a closed session first, and then we can still put it on other matters for that night based on what we do at a closed session. I don't know. Thank you, Mr. Mayor. Well, I'll make a motion that we have the city attorney review the items in the mock jury and bring it to us at a closed session. At the same time, put this on other matters for that same night's meeting. And the outcome will be based on what we've learned at a closed session. So I think we can make a more responsible decision on whether to release it or not.
Okay, is there a second for that?
I'll second it.
And I assume, Peter, that's a substitute?
Yes.
Okay. Is there any more discussion?
Well, I would like to speak to the substitute motion. I'm not sure I disagree with it, but I feel that there's no reason why we can't discuss this at the next meeting. I mean, the notion was that it's material out of context. It is already out of context in relation to part of this information has been revealed, it's been characterized, and the whole study has been characterized. So, and ultimately, as you pointed out, it's archival to begin with. So it doesn't relate to our status now, our situation now. It deals with something that happened back then and why certain decisions were made or maybe certain jeopardy that the city was in. So I appreciate the sensitivity of it, and my concern would be precedent setting, and is it? And that's the kind of discussion that I was interested in having in our next session here, in terms of what are the compelling reasons why we should or should not do this. And I don't have to read the totality of the report to analyze that. So I think I'm inclined to stay with my original motion.
Okay.
I have a comment.
Sure, go ahead.
I do think the door has been kicked open with this, but I always prefer to err on the side of looking at this, since it is a legal matter, to support the substitute motion and discuss it that way first, and then go from that standpoint. I'm not against releasing information that's already been released, at least some of it has. But at the same time, I think I don't want to create any precedents here to just have an open session at this point in time. I think maybe a closed session is a better approach right now. And then hopefully at the end of the day, we'll make the right decision as to taking a position one way or the other on it. So I'll support the substitute motion when we vote on it.
Okay, let's call the question then. All those in favor?
Aye.
Aye.
we done with that? JR, I know you didn't come off your couch for nothing.
You're absolutely right. And unfortunately, J.R. Ravisky, unfortunately on my way down here, I kind of missed what the last vote was on the measure to look at the mock jury.
We're gonna talk about it in closed session and decide it after everybody's had a chance to be fully briefed by the city attorney.
Okay. Well, this happened at the very end of my tenure. And all I ever heard about the mock jury trial was the fact that it did not go as we expected it to go, which is not necessarily surprising about a mock jury trial, because mock jury trials are there to see what the reaction is to our strategy. And if our strategy doesn't work, we rethink our strategy. And why we wouldn't release that, I agree with Mr. Duclos that this should be public knowledge and public record, and let everybody see what the heck happened at this mock jury trial, because I never knew. I mean, the city manager told me that it didn't go well, and that was it. That was all the information I ever got from the city manager and from the city attorney. It didn't go well. What the hell does that mean? I just never saw anything in writing as to why it didn't go well. The transcripts of the trial, which when I was on the council for my 16 years, I looked at many, many trial transcripts. Not necessarily mock. Unfortunately, they were all real trial transcripts and why we won or why we lost. But I would really like to see the transcripts of the mock jury trial to see what happened. Why did they think that we were bad guys and Macpherson was a good guy? I just can't fathom that. And Mr. Mayor, you used that in your State of the City address, justifying the reason that we made this settlement agreement with Macpherson and E&B, but there was nothing to substantiate that other than the fact that it didn't go well in the mock jury trial. So let's let everybody decide whether or not it went well or it didn't go well. And, as I said before, mock jury trials are just mock jury trials, so they don't mean anything in real law. I mean, they're there to decide, did we put up a proper defense? Did our strategy work? And if it didn't, we adjust our strategy and do it again. So I would urge you that when this comes back to you guys, that let us all look at it. I mean, why is it secret? I mean, there's no reason. It's done and behind us. There's no reason in the world this needs to be secret anymore. So that's what got me off of my couch, and I hope that you guys let all the rest of us know what the hell happened, because I sat up there with you guys and I don't know what the hell happened. So that's my say. Thank you.
Okay, thanks, JR.